Pallavi, live on the airwaves of Anisha Radio 104.9 FM. And very quickly, do want to share the number in the studio, 972-235-5555. A very good morning to you, Pallavi, and a very happy new year to you.
To you as well, Meetu. Thank you so much. Glad to be here this Wednesday morning. And yes, this is our New Year greetings to our listeners and to the community who participates here every Wednesday. Thank you for your support and the fact that we're here answering questions every Wednesday. And the amount of calls that we have show a very, very active listenership as well as interaction with us. So we appreciate that. And I know that I've seen the calls starting to come in. So let's start taking our calls and see if we can answer them.
All right, let's do that. 972-235-5555, number in the studio. All right, you are live on the air. Go ahead and ask your question to Pallavi.
Good morning. My question to Pallavi is, recently I heard that those who have an I-140 approved, if they decide to move to a different organization, they do not have to the new organization does not have to reapply the I-140. And is that right? And if so, how does it affect the EAD holder of that H1, dependent of that H1 holder?
Yeah, so that is not accurate. That information is not accurate. With the I-140 approved with one employer, if you need to reuse it to or use it to apply for your 485 eventually, you need with employer B, if you've moved on to employer B, a new perm and an I-140. However, upon the approval of the I-140, that priority date, which we always knew belongs to you, has been now codified to where it will belong to you. Plus, you can use that I-140 approval if it's been open for 180 days. You can continue to use it for AC-21 purposes for H1B extensions. So if someone runs out of the H1B time and they pass their 6 years, now you have an I-140 approved. It had been approved for over 180 days. And that is the I-140 that you will keep referring to get 3-year extensions. But if you want a green card out of it, you do need the current employer to have to do the entire process and recapture this priority date.
Okay, so this information is not accurate. Thank you for that. That's all I wanted.
All right. All the best to you.
All right. Thank you for your call. Once again, 972-235-5555. That's the number in the studio. This is Your Business Matters with Pallavi Ahluwalia. Go ahead and ask your question. You are live on air.
Good morning, madam. This is Bharat. And actually, I'm on my 9th year H1B visa. I got my I-140 approved with my previous employer. And 6 months back, I moved to this new employer. So actually, I'm planning to apply for my spouse's H4 EAD renewal.
Okay.
I just checked with my previous employer last week regarding my I-140, and they said they did not withdraw my I-140.
Okay.
So my question is, can I apply for H4 EAD renewal for my wife based on I-140 approved?
Yes. So basically your question is, you've moved from one employer to the other. You have an I-140 approved with the first employer, and now you want to use that same open I-140, which has not been withdrawn by the employer within the 180-day period, to be able to extend your wife's H4. The answer is yes, you can continue to use it. So, but you have to understand one more thing. If it was to be withdrawn at any point, then she cannot use it. But if it's open at this point, whether it's over or under 180 days will not impact. At any point, any H4 has to present an I-140. It has to be open and not withdrawn.
Yeah, it is not withdrawn. I will just check with them.
Perfect. Then you're fine.
Okay. Thank you, ma'am.
All right.
Thank you for your call. Going to our next caller, Fun Asia Radio. You're live on the air. Go ahead and ask your question to Pallavi.
Yeah, my daughter and her family came here from India on immigration visa. They have they received Social Security cards. Also, they have this passport stamp for 1 year visa.
Okay.
They're going back on January 15th. Would they have to have that green card?
Yes, absolutely. Yes, absolutely. So basically, they have to come. They have to come here and wait till they have the copy of the card that they get. So they have to get that card in their hand before leaving.
But they already, their passports are already stamped for
Yes, but then that is only got a limited validity, sir. That's only for a year. Sometimes they give it to you for 6 months or a year.
But they cannot leave without the green card?
Yes, this is the point where they want you to come and be residents and then process your... So fingerprinting was done. Was it done at the port of entry? Was it done by CBP?
Yes.
Okay, so then you may want to initiate an InfoPass appointment to understand how far is the card production, how far is it in terms of processing. But the advice would be for them to get that green card prior to leaving.
Or they're already planning to go back on January 15th.
Yeah, so again, I mean, we can advise you based on what would be the correct way to proceed with this. I understand their travel plans, but I would say that in the exercise of caution, not for them not to travel, but to get that green card with them before they leave.
Okay. Then another question. My one grandson was included in the immigration visa. His name was there in the interview later. But meantime, they married and they were older grandson. And he was not included in the immigration procedure. So is it possible for him to apply again on the same?
Yeah, so the only time, so once somebody gets married, then if you're a green card holder trying to sponsor your son or your daughter, you don't have that option. You have to become a U.S. citizen to be able to do that.
Okay. Thank you,
so, they'll have to become U.S. citizens and then they can sponsor the married child.
Sure, thank you.
All the best.
All right. Thank you for your call. 972-235-5555. That's the number in the studio. This is Your Business Matters with Pallavi Ahluwalia. And for consultations, you do need to take an appointment. You can call their office at 972-361-0606. ahluwalialaw.com is their website. Going to our next caller. Fun Asia Radio. You are live on the air. Go ahead and ask your question.
Hello?
Yes. Please go ahead and ask your question to Pallavi.
Okay. I'm currently on OPT. I have recently got to hear that ACS correction has been lost. So is there anything that relates to if I want to apply for extension? Is there any possibility for that one? Or
so I didn't understand what got lost, sir. So you said you were on an OPT and then what happened?
I'm on... my college has lost the ACS accreditation.
Okay, all right. So basically, they are not accredited to hold I-20s?
Yeah, for the future extension, for a future STEM extension.
Okay, yeah. So you if the college does not have the accreditation that's required for them to be universities that can hand out the I-20s and the related benefits, then you may have to lose that and re-enroll in another school. So basically, that STEM extension, the 24 months that you were going to get more, will have to just go away.
Oh, okay.
That's unfortunate, but yes.
Okay. Thank you.
All right. Thank you for your call. Going on to our next caller, Fun Asia Radio. You are live on the air. Okay. Moving on. 972-235-5555 number in the studio. Going to our next caller, Fun Asia Radio. You are live on the air. Yes.
Good morning. I have a question. I applied for my citizenship and my fingerprint were done in August 15 and still I'm waiting for the interview for the citizenship. How long normally they do that one? And a supplementary question is that, another supplementary question with this issue, my spouse is here and I want to file a petition I-30. Could I do right now or I have to wait till my citizenship completed and apply for I-30 including work permit?
Okay, so let's get the two questions. So first question is, how long is the naturalization process taking? It takes about 7 to 8 months, sometimes even 9 months. So if you got fingerprinted in August, they must be still doing the background checks for them to set up an interview. After you get set up for an interview is where you're closer to getting naturalized. Now, for which category were you planning on doing the I-130?
I-130 because I am a permanent resident since almost about 8 years.
Yes, but for who were you wanting to sponsor the I-130?
My my spouse.
For your spouse. So as a green card holder,
She is here.
Yeah,
She
so
is
as a-
here.
Go ahead.
She is on visiting visa.
yeah. Okay, so if it is for a spouse who is here on a visitor visa, you'll have to get naturalized prior to being able to file an I-130 and a concurrent 485 for her. However, as a green card holder, you can still sponsor the I-130, but she cannot stay back because of that. It will have to be filed just as an I-130 because it's not a current date. It's about 2-3 years behind. She'll have to wait for that date. So after her visitor time, which is the I-94 that expires, at the time that it expires, she'll have to leave, and then she'll have to wait for the rest of the processing outside and return to the country after staying out for a decent amount of time. But you can't
What is
sponsor
the
her.
best idea?
I'm sorry?
I have to file I-30 or I have to wait till I complete my citizenship?
So to do it where you are a U.S. citizen and she wants to file an adjustment, you have to be a U.S. citizen first. But just even green card holders can sponsor their spouses. It just has a 2.5-3 year wait.
Okay, thank you. Appreciate it.
Okay, bye-bye.
Thank you for your call. 972-235-5555 number in the studio. Going to our next caller. On Asia Radio, you are live on the air. Go ahead and ask your question, please.
Hi, I have a question for my father. Actually, I applied for his green card and it got denied. And it is a mistake from the USCIS. They said that they did not receive the documents. However, I applied for my mom at the same time and they received those documents and my mom's green card got approved and my father's green card got denied. So now my father wants to go back home and I will do a consular processing for him. And I just want to make sure that I know when I will do a consular processing for him that it's not going to be he cannot come back as a visitor visa and it might take. So I just want to know that how long does consular processing takes, and I just want to know that I know about the bar of 180 days. So is it going to be a bar of 180 days from where his visa expired or from when?
Yeah, I would not. At this time, if you have to refile for your dad, I would not advise him to leave the country. Because if he does, he will have the 10-year bar to entry, not a 180-day bar. So if somebody has violated status, meaning your 480, your B1 or B2, whatever he came in on originally, had expired and then an adjustment also got denied, he has been, from the date that the I-94, the first I-94 expired, he's been accruing unlawful presence. And because of the accrual of this unlawful presence, his stepping out will get him into, so was that time that all this pending must be over a year, correct? By the time you got a decision on the 485, was it over a year?
Oh, no. It just came in December 19th, and he's preparing to leave right now.
Yeah, no, but from the time that the I-94 expired earlier, the B1, B2 I-94, it's been over a year since then, or no?
No, it has been 6 months. His I-94 expired in July. Because he came on visitor visa in February. I applied for him in March, and his visitor visa and the I-94 expired in July. And he got a decision in December saying that it got denied from a for an internal mistake. So now he wants to go back because that's what it says. And so when he goes back, I want to do a consular processing for him.
Yeah, the consular processing sometimes can be a little bit of an issue, especially if somebody had a denial before and we haven't, since I've not looked at the passport and I have not counted the dates, if it's been over 180 days since that's expiration, then he will have trouble coming back in as well. So
and he doesn't have it hasn't been 180 days yet. So that is what my question was.
Okay, so the expiration in July, and you've counted the time from the date of the I-94 expiration, and it's not 180 days. So here is my concern here, and I say this as a general statement. For me to permit or say that he should be okay requires me to be able to have way more visibility to his case before I say that. Otherwise, my word of caution to you would be he may be better off with doing another I-130 and 485 here in the country. So the
okay.
decision that you got is a generic
Yeah.
statement saying that his case has been denied and he's accruing unlawful presence. That's just a generic worded denial. But that doesn't mean that he has to leave. The better strategy may be for you to reapply and do the 485 for him here.
Oh, okay. And is there any way I can do an info pass and let USCIS know that it's their mistake that they didn't get
so for you to do
documents?
that, then you have to do an MTR. So from the
What
date that you get your denial, you have a motion to reopen, reconsider, and that option must be there on your 485 denial. So look at the options that they're giving you. So if you think that it is a mistake they made and you have a proof of what was submitted to them, then I would advise that you do a motion to reopen, reconsider. Meanwhile, let Dad not leave and be here.
Okay, thank you so much.
All the best.
All right, thank you for your call. And 972-235-5555. That's the number in the studio. Pallavi Ahluwalia from Ahluwalia Law Offices is here with us answering all your legal questions. So going to our next caller, Fun Asia Radio, you're live on the air. Go ahead and ask your question, please.
Hi, good morning. My question is, I'm right now planning to apply my fifth H1 extension. I already have I-140 approved. And my question is, will I be able to apply for H4 EAD extension in parallel to my H1 extension?
Yes, so basically if you're doing an H1B extension and you're doing it under premium processing, you have your spouse's H4 included in that as well as the EAD. That's the smartest way to approach it, because the H4 will quickly get adjudicated along with the H1B, and then the EAD from that time may not take that much time. Right now, based on the new regulation that is going to be effective on January 17th, the government can take up to 180 days to approve the EAD, which means that it's smart to just at least get the H4 done along with the H1B under premium processing.
But I'm not planning to apply for premium processing because I still have 7 months. So usually my company starts the process 6 months in advance only. So at least I'm not planning to apply for. So your suggestion is to apply in premium processing because of the changes in the rules?
Correct. Because otherwise she's going to be waiting almost 8-9 months, 10 months even to get the H4 and the EAD based on the new regulation.
And if I apply it now with the premium processing, it will be able to get it through because it is before the new decision.
Yeah. So one thing to be clear about: you cannot apply before the 180 days.
Right. So my 180 days will start, like it will be on 17th of January 2017.
Okay. So that's when you're eligible to apply for the extension. You can apply only 6 months prior. Okay.
Right.
So at that point,
on that given date, I need to apply with the premium processing so that it will be faster and it will not go through that particular 8 or 9 months of H4 EAD processing, right?
Correct. So what I'm trying to do is to get the H4 sorted out, so the H4 gets approved for the required length of time within the 2-week frame, and then the EAD can take whatever time that the government has now asked that it should take.
Okay. Okay. Thank you very much, ma'am.
All the best.
Thank you for your call. Going on to our next caller, Fun Asia Radio, you are live on the air. Go ahead and ask your question, please.
Hi, good morning. This was a question regarding my wife. My wife is in US on H4 visa, but she has a valid H1 petition filed through consular processing last year.
Okay.
So I wanted to check if we can do a H4 to H1 a change of status here within US.
Yes, that's possible.
And if so, like how much the fees and the processing time it would take? Is it the same as the new H1 application, or it could be less than that?
No, so you're going to do it. Is it going to be for the same employer that sponsored her in the first place?
Yes.
Okay.
Yes.
So then this goes under an amendment. So this change of status has to be done as an amendment, and then what would apply would be the base fees, and the base fees. Let me see if I can give those to you. Are I think 540, and if you do it under premium processing is when you can do this quickly.
Okay, so if it's with the same employer, it's just an amendment, not a change of status?
So if it is with the same employer, then it would be done as an amendment for a change of status.
Okay. So the fee is not exactly the same as the new H1 application. It will
Correct.
be
It's
the fees
lower.
for the amendment.
It's lower. Correct. It's the base fees for the H1B, and if you're doing the premium processing service, then it's that extra $12.25.
Okay. And another thing, like if my wife goes for H1 stamping in India, and unfortunately if it gets into administrative processing, does the travel to US on H4 visa gets blocked, or will be able to travel?
Yeah, no, she still has the option. She still has the option to be able to enter the country and give up on the H1B processing and enter the country on the H4.
And looking at this time frame, do you recommend going for H1 stamping in India, or it will be best to do a change of status here itself?
Yeah, at this point, I think the safer bet may be to just do a change of status here. That may be better. We hear a lot of cases, just the regular cases are going through 221Gs, so which is administrative processing, and that's being done even for the Dropbox kind of cases. So if it's a new case, I'm sure they would like to check out the employer properly as well as what she's going to be working on. So I would advise doing it here. It would be more efficient.
The last question is like, if she arrives in US on H1, like, or if her status changes to H1 here, is it mandatory to have a payroll started from day one?
Yeah, so when she enters on H1B, then the obligation to work as well as be employed and show up to work, get paid, begins on the day she arrives.
Okay, all right. That's all I wanted to know. Thank you so much.
All right, thank you so much. And that's pretty much it. We have 30 seconds to go and do not want to take a call because we won't be able to complete it. Any final words for our listeners here?
Yes, well, this is for everyone out there. Just be aware of the rules because I'm hearing a lot of versions of the January 17th rule about what's required and what's not. Also, one more thing is the 485, if you're getting eligible to file a 485, there is a new supplement that's going to be required for most employment-based cases, which is a supplement J. So be aware of that when you're filing your case, and that will be required soon after January 17th.
All right, perfect. And thank you so much for coming into the studio. It's always great to see you, Pallavi.
Thank you, Meetu, for hosting me so well. As always, appreciate it.
Thank you.
Thank you. Bye-bye.